I am Simeana BESHİ, the PhD student. I work as a teaching assistant at University of XIX Prison, Republic of Kosovo. Today I will share with you the results of my research paper of the topic the principle of proportionality based on the jurisprudence of European Union Court of Justice. The paper has this content: the aim of the study, research methodology, literature review, interpretation strategies used by the European Court of Justice in issues involving value-added tax, proportionality principle, case analysis, and the conclusion. The aim of the study is to analyze and understand the application of this principle of proportionality in European Union law, to analyze and understand cases in which the European Union Court of Justice has applied the principle of proportionality and how it has interpreted and developed the principle over time. Also, the researchers can gain a deeper understanding of how European Union institutions balance competing interests and values when making decisions. The research methodology used in this paper is a methodology that involves qualitative research methods, case study analysis, and comparative analysis. The principle of proportionality has been developed by the Court of Justice of the European Union, deriving from the rule of law, and requires in particular that the individual should not have his freedom of action limited beyond the degree necessary in the public interest. The principle of proportionality for the first time was mentioned in the decision that the Court of Justice made in the case of Fedesha. The court did not explicitly cite proportionality until it handed down its verdict in the international Handelsgesellschaft case. This principle is stated in the third paragraph of Article 5 of the Treaty of European Union. According to the proportionality principle, Union action should not exceed that which is necessary to accomplish the purposes of the treaties. The article goal is to try to address the topic of that function the proportionality principle serves in the value-added tax system. This main goal will be attained through 18 specific goals, which are considered to be the following questions and their respective answer. So the research question of the topic is, does the European Court of Justice commonly use the principle of proportionality when interpreting tax law provisions? The hypothesis of this topic is that in tax cases, the European Court of Justice applies the content of proportionality in conjunction with other European Union principles rather regularly. This is done in order to guarantee the defense of taxpayers' rights alongside other European Union principles. Interpretation strategies used by the European Court of Justice in issues involving value-added tax proportionality principle. The European Court of Justice is the institution that is tasked with resolving any interpretational questions regarding the value-added tax directive. If national member states courts are unsure how to interpret elements of the value-added tax directive that must implement into their domestic law, the European Court of Justice may give guidance for the right interpretation in order to ensure that it is carried out correctly. Due to the European Union Value-Added Tax Directive, which must be applied identically across all European Union member states, as well as the jurisprudential ramifications of the court, the unified value-added tax system has developed into a truly European tax. This is the result of the European Court of Justice jurisprudential decisions. Even if there has not been any uniform harmonization, the court continues to emphasize the significance of the domestic legislation that are implementing the directive into force, being interpreted in a manner that is in accordance with an in line with European Union law. The Value-Added Tax Directive Article 131 grants member states a broader range of discretion, allowing them to, for instance, impose restrictions on the use of exemptions in order to guarantee against potential fraud, abuse, or avoidance. If a member state chooses to restrict the taxpayers' European Union rights in this case, it must ensure that it does not go further on what is necessary to achieve the purpose it is following, that is, that the measures adopted to achieve the goal are proportionate to the goal. This is known as the proportionality principle, and it pertains to what? Here we can analyze the cases about Sosnovska and Grupa Varzina. In the first case, it issued in the Sosnovska case, the European Court of Justice ruled that Article 18, paragraph 4 of the 6th Directive 77/388 is in conflict with national law, which extends the time frame for domestic tax authority to reimbursement excess value-added tax amounts paid while absent of a substantial bond from 16 to 118 days, beginning on the day that taxpayers of specific categories file a value-added tax submission. This national regulation is intended to make it easier to oversee tax avoidance and fraud. The other one is the case Grupa Varzivna. On April 15, 2021, the European Court of Justice issued its decision for this case, dispute on the accordance of Polish laws with European Union law. This case relates to the ongoing continuous issues of value-added tax sanctions. A Polish corporation named Grupa Varzina bought a real estate that had been owned for more than 2 years. The real estate seller sent out an invoice collecting value-added tax. Grupa Varzivna filed a reimbursement request for the value-added tax paid on the bought real estate. The claim was denied by the tax office on the grounds that the real estate transactions should have been value-added tax exempt. Grupa Varzivna was not permitted to remove the supplies input to value-added tax according to the tax authorities. The tax authorities assessed a penalty of 20% on the value-added tax amount of the purchase, even though the firm amended its value-added tax return appropriately and reduced its deductible value-added tax amount, claiming that the first value-added tax deduction was invalid. The corporation objected to the authorities' strategy, and eventually the court was asked to rule on whether a penalty similar to the one imposed by the Polish authorities was permissible under European Union law. According to the court reasoning, since penalties are not included by European Union value-added tax directives or value-added tax rules, there is no harmonization of penalties under European Union law. Member states are totally within their rights to qualify, determine, and apply whatever sanctions they see necessary. However, the principles of proportionality and value-added tax neutrality, the two foundations of European Union law, must always be respected. Respect for the neutrality principle manifests itself in the ability of value-added taxpayers to deduct the input value-added tax sums incurred while engaging in value-added tax register activity. Only extremely rare circumstances such as fraudulent behavior allow for the restriction of this freedom. Penalties that limit or abolish this right are thus in violation of European Union law. On the other hand, a number of reasons, such as the one that stipulates that punishments shouldn't go beyond that is absolutely required for the objectives achieved, crystallize the notion of proportionality. It is important to take into account the kind and severity of the violation that the penalty tries to punish. In conclusion, it can be concluded that they cannot be out of proportion of the gravity of the incident, particularly when no loss or losses of value-added tax income occurs. In the Grupa Varzivna case, the corporation erred by incorrectly determining how a particular transaction should be treated for value-added tax purposes. Nevertheless, whether the intent was discussed, whether the mistakes results in a loss of tax income, or whether other unique circumstances were taken into account or not, the punishment remained the same. For these reasons, the court concluded that the punishment in question abused the European Union principle of proportionality. It may be concluded that value-added tax penalties that are arbitrarily applied without taking into account the unique circumstances of each instance are in violation of the proportionality principle and as a result are not in line with European Union legislation. The principle of proportionality is a key element of European Union law which ensures that any measures taken by the European Union institutions or member states is proportionate to the objective pursued. The principle requires a three-step test, which involves assessing whether the measure is suitable, necessary, and proportionate in the strict sense. The suitability test requires the measure to be appropriate to achieve the intended objective, while the necessity test requires that the measure is not excessive in relation to the objective pursued. The proportionality in the strict sense test requires that the measure is not disproportionate to the objective and that the measure is the least restrictive option available. In conclusion, the principle of proportionality is a fundamental principle of European Union law, which ensures that any measure taken by the European Union institutions or by member states is proportionate to the objective pursued. The principle has been developed by the European Court of Justice through its jurisprudence, and it has been applied in various fields of European Union law. The principle of proportionality is integrated into Article 5 of the Treaty of European Union and also applies from the law of the European Court of Justice in order to avoid fraud, evasion or abuses in the domain of VAT. As a result of the evidence presented earlier, as well as the discussions that followed, we have arrived at the following conclusion. In order to avoid possible evasion, fraud, or abuses, it is required to strike an acceptable balance between the harm to the core principles and the goals of the common value-added tax system and the authority of the European Court of Justice. There are two components to this definition. First, and main, the measure must be designed to stop potential evasion, avoidance, or abuse. Second, the extent to which the common system of value-added tax is undetermined in order to achieve this objective must be proportional. The jurisprudence of the European Court of Justice has an important function in the discussion of this matter. Thank you for your attention.